Thank you, Mr. Chairman, members of the committee. For the record, my name is Curtis Trent, representing Senate District 20. Senate Bill 74, very plainly a DWI diversion program that would allow the dismissal of first-time intoxication-related offenses with the completion of the diversion program, including the use of an interlock device system. The hope is that this program will create an off-ramp for first-time offenders, and while providing assurances that leniency through the program will not result in higher risk to the public because of the use of the interlock system. It's a pretty straightforward program, and I would be happy to answer any questions the committee has.
Any questions for Senator Trent? Seeing none. Witnesses in support.
There we go. Good afternoon, and thank you very much for letting me address Senate Bill 74. My name is Mike Boland, and I'm a volunteer for the organization Mothers Against Drunk Driving, or MAD, if you will. I'm going to try and be very direct in my testimony, so I hope I don't offend anybody, because I know there's a lot of attorneys here, so I'll caveat that right ahead of time. We'll see at the end where we're at. As an organization, we at MAD usually don't approve of diversion programs. But in the case of Senate Bill 74, I don't see it as much as a diversion program. I see it as a second chance bill. Because if we use this bill correctly, it gives someone the chance to avert the possibility of killing, injuring someone, or destroying a family by using a simple device that stops the crime from ever happening again. And hopefully we can add an educational component to this bill where we can educate those to the dangers of drunk driving and the consequences that result. We can do this by understanding the problem with the use of numbers. Not mad figures, numbers, simple studies that have been done. First, the misnomer of the term first offender. We seem to want to be lenient for someone that gets a DWI the first time. We know two simple facts. If you're stopped by an officer and you're ticketed for a DWI, that the Center for Disease Control, the FBI, and many serious research scientists state the fact that a first-time offender actually has driven at least 80 times before they're caught. I think that's why it shouldn't be a first-time offender. It's the first time they're caught. And after that, they're caught, and they get the ticket. This is where I'm going to offend some attorneys. You can look up in the phone book and look under attorneys. You can find every way around a DWI. This bill addresses that getting around it. Now, if we take the 80 times that someone possibly could be driven, and then we look at the data, we look at the police. An extremely tough job right now. We know that most police departments are understaffed, overworked, and fearful of what will happen with them, as well as are not sure where the prosecutors will go with it. Doing their job, the best the police can do to apprehend drunk drivers is 5%. That's to be delivered by Biddle, Sharp, and Glaze and in injury prevention. So therefore, if we use the data and look at what we need to look at, a first offender is driven at least 80 times, and the police can only get 5%. The numbers appreciate exponentially. We need to augment the problem with the help of technology, this little simple device. By the use of this device of interlock, you just blow into it, and the device won't let you start your car. Or if you're driving your car and it asks you to blow into it, it gives you a rolling restart. It gives you time to pull over and deal with it. So there's no safety system to the driver or to the public. But by putting one on the car, we give everyone the peace of mind, the added security where the offender cannot offend again, The public is safe and the roads are safer. And our police can do work on other crimes. We can achieve this safety measure with a proven track record, and that's the use of interlocks. The first state to start using interlocks was New Mexico. And they had the highest fatality rate for drunk driving in the country. They instituted the interlocks and they dropped significantly. But most of all, what they found that's included in this bill is that putting an interlock on a car for a minimum of 1 year slows the case of recidivism. 6 months is not the standard that works. It's actually just a year. And Senate Bill 74, it's included in a year's term. I don't know how all you feel about the recreational marijuana that has come to our state, but we have looked at other states that have instituted recreational marijuana. First one, Colorado, Washington State, and their numbers have driven up consequently because of passage of recreational marijuana and the fact that there's usually alcohol and polysubstance abuse in most traffic stops. So using technology, we can help mitigate that problem. The offender ends up pleading, I skipped a page, sorry. It's been a while since I've done this.
Or we will, just so that we have the benefit of having all the witnesses be able to testify, if you could wrap up in the next minute or two, that would be
I'll
helpful.
try. I mean,
Thank you.
I'll simply tell you, I don't know how many of you have children. I have 4. And when my son was 5 years old, he was affected by a drunk driver. I guess I'm one of the lucky ones because my son didn't lose his life. His best friend did. He was traveling down First Capitol Drive in St. Charles, Missouri, when a man, first-time offender, hit Matthew Yarkey, put him 40 feet up in the air, 40 feet out, and the man left the scene of the crime. There was 2 officers, one on a side street, one behind him. The one behind him went and apprehended the offender, and the one on the side tended to Matthew. His injuries were so severe that police officer, who was brand new, never worked as a police officer again. And the other police officer has struggled for the rest of his career. I was left needing to do something, as I had to explain to my son when he asked me, why do people I love die? And that's how I got involved with MAD. And I knew at that time the only way I could solve this problem was change laws. And for the last 30 years, I've been coming up to the Capitol trying to change laws and been successful in some of them. But in Matthew's case, I wasn't because the law wasn't on his side. The man pleaded to a DWI, but never had to deal with the manslaughter because the act of driving drunk in Missouri was not enough, just a DWI. There's also, I have with me today, two associates that work with MAD. Jared Bright is our new regional executive director, so if you have any questions for anything for the state, he can ask you that. And a very special young lady, Megan Carter. She's our national employee, but more importantly, she's my friend. And 20 years ago, she lost half of herself. She's the one of a twin, and her brother was killed by a first-time offender. I think the repetitive thing here is that it is first-time offenders. That's what this bill can do. So I'm asking you, and I'm hoping that we can work out any of the kinks and anything we can do to help would be more, and you pass this bill out of committee. With that, if you have any questions, I'll be more than happy to ask.
Great, thank you for your testimony. Any questions for the witness? Seeing none, thank you for your testimony. Don't forget a witness form if you haven't filled one out already.
Thank you
And then,
very much.
Can I get a show of hands? Do we have any witnesses in opposition here today on this bill? One. Anyone else? Okay, we'll go ahead and do witness in opposition then first. Okay. And then we'll switch back to support.
Thank you. Members of the committee, my name is Ben Faber. My name is Ben Faber. I'm a board member of the Missouri Association of Criminal Defense Attorneys. Here to testify against this bill. So I think first and foremost, it's important to be skeptical of any criminal defense related law or criminal prosecution related law that requires the installation of an ignition interlock device. There just simply isn't room for industrial profiteers in the criminal justice system. All of the things that this bill claims to create are already in existence. Prosecutors can already divert DWI cases. Judges can already require ignition interlock devices as conditions of probation. There's a disposition in the courts in Missouri right now. It's called a suspended imposition of sentence. It's 2 years of unsupervised probation, after which time the case becomes a closed record and there's no conviction. It's not an uncommon disposition for first offense DWIs. This bill, the diversion program that it names, is essentially an SIS, or a suspended imposition of sentence. However, there is a requirement with this type of SIS that the individual pays ignition interlock device companies about $100 a month for at least a year. The courts can do that on their own with an SIS if they so wish. The judges have that discretion. The prosecutors can require that as part of a plea bargain, but it is not mandated by the legislature. To that point also, any added expense for a criminal defendant in a criminal case, many of which are indigent, should be looked at very cautiously, because it has the serious potential to create disparity, of which there's already so much.
Mr. Faber, can I interrupt for just a second?
Yes, sir.
So you said right now a prosecutor or a judge can recommend an SIS, and as a part of the term probation require that they install one of these interlock devices. I mean, even if the bill passes, a judge could still do that, right? Because this language in Senator Trent's bill is just an option that's provided to the judge. So would that not still be the case?
It wouldn't strip the courts of the authority to do an SIS. But my concern is that you have someone come into court, for example, pro se, right? And this individual wouldn't necessarily even need counsel, whether it be private counsel or a public defender, to give them advice on this. And they hear this word diversion, right? Oh, it'll be completely dropped when you're done. Just go ahead and pay all this money and do all this participation. And I think you're going to have a lot of people wanting to do it. It doesn't necessarily benefit them any, because they're not, and this is strange, and I don't think this would actually last very long, because the very last text, the very last provision of the bill names someone who has completed a diversion program as a prior offender under the DWI recidivism laws. That person wouldn't have pleaded guilty to an offense, or maybe if they were, which I didn't notice anything that would have required them to plead guilty or be found guilty to go through the diversion program. But without the advice of counsel, or without a waiver of counsel, this person would then be considered or subject to an increased range of punishment for subsequent DWIs, having taken advantage of this, quote, benefit, right, in the diversion program. And that's in that Supreme Court case is Apprendi, where any prior convictions and anything that serves to increase the minimum punishment for a case needs to be proven beyond a reasonable doubt. So in a diversion program, you just, who in here wants their DWI dropped? Everyone raises their hands, goes, signs up, pays the money. If this person's an addict or a recidivist, they come back. And, this first DWI case that they had, causes this double punishment or increased punishment, where they may not have had the opportunity to address that on the first offense.
So isn't the answer then in the bill to just say that they have to plead to an SIS, and then it's the imposition of the sentence is then enforced if they violate the terms of the diversion program?
Well, I think that's the way things already are. I mean, the
But
answer.
I'm saying the potential constitutional issue that you brought up with the bill, I mean, isn't that resolved by just saying they have to plead and then they go into the diversion program?
Yes, it could be that specific issue. Now the question arises whether that person would be required to have counsel, whether it's public counsel or private counsel, and then why they would take advantage of this, right? And I don't see any. There's nothing in this bill that's not being done better already, really is my take on it, and it's the position of the Missouri Association of Criminal Defense Lawyers. Also, we've had circumstances in the past with legislatively mandated diversion programs where if one offense has a diversion program, then it causes courts, prosecutors, defense attorneys, and citizens to balk at other types of diversion programs, because if there's a law allowing this type of diversion, well, why isn't there a law creating this other type of diversion? And diversions are actually used very frequently in criminal justice. They're very effective. It's sort of like a double secret probation in a lot of cases, which, you may have a situation where, everyone's getting what they want, right? The court is getting their promises. The state, the prosecutors are getting, that sort of, they've still got the stick, and then the diversion is the carrot. And what this does is it causes it has a serious potential to cause the false perception that this is the only way a case can be diverted. And we have seen that in the past. I think in St. Louis County there were some issues where it was sort of a cluster right at the end of it.
We're going to interrupt again for a second. Senator Rader, you have a question.
I do. Do you know how many of these interlocking companies there are?
In Missouri, I think 4 or 5. There are several.
The reason I ask, I've had in my years of serving, that's one of the issues that I've actually had pretty consistent from constituents or people who have trouble with the interlocking systems. Why I was asking, I was wondering if there was like 1 or 2, and then
I think there's 5, but they're all nightmares, right? I mean, they provide really poor service generally because it's not a choice that the people have.
it's difficult for someone who uses their vehicle for work. It is incredibly difficult. But I get it. I get the reason why, and I think it is a great diversion program. But then my second question is, are there other states that are doing this by statute like this?
I don't know.
And then lastly, for you, Senator, what is the difference here? Like, why would we do something that looks like it's already what our judges and prosecutors are doing now?
Well, I think there's value in putting statutory framework around this kind of program so there's consistency in how it's applied. And I think the hope is that this would get more people to use an interlock system, which would prevent recidivism in a moment of weakness while people are trying to work through this problem.
Okay. Thank you. Thank you.
Any further questions for the witness? If you have any other testimony, we can take written submissions. We just got to keep the hearing moving along, so appreciate the testimony. Any further witnesses in opposition? I didn't think I saw any. Are there? Okay, further witnesses in support.
Thank you, ladies and gentlemen of the committee. My name is Cody Carlson. I am here with the Coalition of Ignition Interlock Manufacturers, National Ignition Interlock Coalition of manufacturers around the nation, here to testify in support of Senate Bill 74. I have a few general data points, and then I'm here to answer any technical questions you may have around the device itself. In general, we do know, and we have studied, ignition interlock devices have stopped over 3 million, nearly 4 million drunk drivers from starting their vehicles since 2006. Ignition interlock devices help prevent recidivism going on and having a second offense, a third offense, by nearly 70% when compared to just license suspension alone. And convictions, including DUI, as by the Brennan Center of Justice on a person's record, can cost that individual hundreds of thousands of dollars in potential lifetime earnings. We're here in support of SB74 in hopes of stopping those convictions, in hopes of preventing further and future convictions. And as I said at the beginning, I'm here to answer any technical questions you may have around the devices themselves.
Thank you for your testimony. Any questions for the witness? Senator Rader.
Do you feel that this bill will increase y'all's use, the use of the interlocking, or do you feel it's just simply putting the framework in that's already existing?
We feel that this bill does add the benefit of choice for the defendant. As far as the specifics of how the Missouri court system works currently, we do think that there is a value in providing a statutory framework around that. But I am not familiar with the Missouri court system and how it currently is in use. We do believe that this would allow for defendants to have the choice of utilizing an ignition interlock device under the parameters of the diversion program in a way that would benefit them in the long run and stuff.
Do you have any statistics on how often your systems fail or how often people have to have them replaced or spend downtime at the DMV or wherever they go to get it downloaded and then it's not recalibrating properly? And
As far as failures go, all of our devices undergo National Highway Traffic Safety Administration testing standards, which in order to pass during those tests, they have to 100% of the time not detect alcohol that is not there.
I mean, more like when the system isn't working, like when it shuts down for no reason. Like, do you have some statistics on that, on how long? I've had constituents who have called me and they're like, I'm sitting in a parking lot again having to wait to have this thing.
Test for a failed startup or something like that. In Missouri, you have the opportunity to start your vehicle, and if there are 3 failed startup attempts within a 15-minute period, that's the only time that there's going to be a lockout of your vehicle. So if you're above that limit for that, that could be a situation where the device has prevented the vehicle from starting up. In that case, it's doing its intended purpose.
I'm talking just system failure, and we can talk offline about it, and I'll just get some details from you. But
Absolutely.
Thank you, Mr. Chairman.
Any further questions for the witness? Seeing none, thank you for your testimony. Please remember your witness form. Because we now have a quorum present, I am going to make a motion that we go in. We're going to establish quorum. Brad, please call the roll.
Senators Luetkemeyer,
Here.
Schroer,
Here.
Coleman, May, Roberts, Thompson Rader, Trent.
Here.
Got it, cool.
We have a quorum. I would now make a motion that we bring up for the committee's. Oh, yeah, I'd make a motion that we go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. We are in executive session. I would now make a motion that we bring before the committee Senate Bill 189. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. The bill is before the committee. The committee should have received a Senate committee substitute for Senate Bill 189, which also rolls in the provisions and bill numbers of Senate Bills 36 and 37. Just for the benefit of the committee, this is Max's Law, which is the police canine enhancement provision that I sponsored. The committee previously passed it out on another bill. And then the provisions from Senator Williams have to do with establishing a conviction review unit, which is a non-binding group of 2 attorneys housed with the Missouri Association of Prosecuting Attorneys that can make recommendations on whether prosecutors should reopen cases. And then there are some fixes to the state's expungement laws. So we also included a technical change that was referenced during the committee hearing. As a part of Senate Bill 53, we had a provision that allowed prosecutors to bring motions for new trial for claims of actual innocence for non-death penalty cases. And we, after a Supreme Court decision that came down on Tuesday, need to clarify that in cases of a change of venue, that those cases are brought by the prosecuting attorney who filed charges, not the place where the conviction occurred. And so that's just clarifying language to fix that issue from the court's decision on Tuesday. With that, I would be happy to entertain any questions. Senator May. There's a lot of stuff in this substitute, Senator.
So in this bill, I think I'm looking at the, is this adding more expungement or what is it?
So generally speaking, it's streamlining the process for expungement. We're not expanding the scope of crimes that you can seek expungement on. Again, this is Senator Williams' bill. It's a petition-based expungement process, but we're modernizing the process. There's also provisions in there that would grant a restoration of rights that, at least under current law, we believe are not restored without these fixes.
And is it, is it adding, when we're talking about restoration of rights, I missed it, I thought I saw it, but I'm not sure. Is it saying the expungement of records, because,
Yeah.
is it adding that portion? Because the expungement we did in 2017.
Yep.
So it's not true expungement.
Yeah, so this would require the destruction of records. I'm actually trying to find the provision where it is in there. The only changes that we made from the version that Senator Williams presented on last week were some technical changes. There were some cross-references that were wrong, and those were fixed. But yes, this does require the destruction of records. And again, I'm trying to find exactly where in the bill that.
That's my point. Restoration of rights.
Okay, I stand corrected. We do not have the destruction of records in here. We have the provision relating to restoration of rights. On page 17.
So we need to add that. Would it be opposed to an amendment adding that?
Senator, I probably at this point would prefer to do that on the floor.
Okay, very good.
Yep.
And so you wrote the other little bill in here too?
Your favorite bill? Your favorite bill is in there, Senator. All right. Is there any further discussion on the substitute? Hearing none, I would make a motion that we adopt the Senate Committee substitute for Senate Bills 189 and roll in to the title Senate Bills 36 and 37. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. You've adopted the Senate Committee substitute. I would now make a motion that we vote do pass Senate Committee substitute for Senate Bills 189 and 36 and 37. Has been seconded. Any further discussion? Hearing none. Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Schroer, Coleman, May,
Aye.
Roberts,
No.
Thompson Rader, Trent. 5-1.
By your vote of
Yeah.
By your vote of 5-1, you have voted do pass Senate Committee Substitute for Senate Bills 189, 36, and 37. I now make a motion that we bring before the committee Senate Bill 227. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. Bills before the committee. Senate Bill 227 is Senator Coleman's bill from last time. This just clarifies that in Missouri law, to commit a homicide offense, you do not have to know the identity of the person you're intending to kill before the murder happens. She had a situation in her district where the person resolved that they were going to kill somebody and pick somebody up at a gas station. They didn't know who the person was. It was a stranger, but they clearly committed first-degree murder, and there was a question by the prosecutor of whether they could prosecute that as first-degree murder. And so this is simply clarifying that if you intend to kill somebody and you're picking up a stranger with the intent of killing them, that not knowing the person's name or identity prior to committing the offense is not a defense to that crime. Any questions? Senator May. Okay, so she,
Basically, first-degree murder, let me get my clarification straight. It's basically premeditated.
premeditated murder. So this just says that you do not have to know the identity of the victim to be charged with that crime. So in this particular instance, I mean, the classic example would be picking up a hitchhiker. You don't know the identity of the person. You're intending to kill the person, but you don't know who they are. That is not a defense to the crime of first-degree murder. Any further questions? Seeing none, I would now make a motion that we do pass Senate Bill 227. Do I have a second? It's been moved and seconded. Brad, please call roll.
Senators Luetkemeyer,
Aye.
Shore, Coleman, May, Roberts, Thompson Rader, Trent. 6-0.
By your vote of 6-0, you have voted do pass Senate Bill 227. I would now make a motion that we exit executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. We are out of executive session. We are back on the hearing for Senate Bill 74, further witnesses and support. We are going to ask that the testimony of any remaining witnesses be limited to 2 minutes, just so that we can get through the hearing in the time that we have allotted.
All right, I'll be much quicker than that. Casey Nail, here today representing Empower Missouri. Also want to go on record in support of Senate Bill 74. We think diversion programs like this are a really good way of holding folks accountable, but also allowing them to continue to meaningfully engage in their communities and continue that road to recovery if that's necessary. So happy to take any questions.
Okay, any questions for the witness? Seeing none, thank you for your
Thank you.
testimony. Further witnesses in support, Senate Bill 74. Seeing none, any witnesses for informational purposes?
Mr. Chairman, members of the committee, Darrell Moore, Executive Director for the Missouri Office of Prosecution Services and Missouri Association of Prosecuting Attorneys. I'm testifying for information purposes, even though as I hear the bill, we're probably for it, especially since it's my senator. But the reality is, it is true, Senator Rader, that under the current system, a prosecutor could do this, but there is value in having in statute a specific diversion program. We would support the bill, and we've been talking with the sponsor with two changes. One, prosecutors generally run the diversion programs, not a judge, and like the drug courts and the DWI courts. So we would like to see that change where the prosecutor makes a decision, because the prosecutor's in a better position to know the defendant's criminal history. And the second thing is we want better language to make it clear that it only applies to the first alcohol offense. Otherwise, we think the bill has great value, because right now, while a prosecutor could do it, it doesn't hurt sometimes to put it into law and encourage prosecutors to do it. When I was prosecutor not too long ago, I believe that prosecutors have the inherent authority to do diversion programs, and we were doing them. But as the one witness testified, apparently in some venues around the eastern side of the state, some of the judges had an opinion that a prosecutor couldn't do that. So as you recall, we sponsored a bill that I wrote in 2019 that specifically encouraged prosecutors to do diversion programs. So that became an official public policy of the state of Missouri. Hopefully that answered some judges' questions. So I don't think there would be any confusion. I do think there's value in this and the interlock ignition devices. Plus the reality is, if we can get them the first time and get their attention and they don't violate again, that is a worthwhile activity, so we do not see them repeating again and again. So I'd be glad to answer any questions.
So, Daryl, I do have a question. So, the first objection I get, the diversion program needs to be initiated by the prosecutor, it's not by the judge. As to the issue of whether this applies to first-time offenders, so on page 2 of the bill, I'm reading the individuals who qualify, and the first requirement is the defendant has not been previously convicted of any violation of driving a vehicle with 1/8, 100th, 1% or more by blood alcohol weight in the person's blood. So, I mean, I guess the concern there is that maybe they've been charged with, and they've just never been. I guess the way I'm reading it is it does deal with first-time offenders. Am I wrong?
Maybe, but we would like it to be clear, and we would like, the correction we would like is to have the specific statutory violations listed, not just saying, so it's clear that it applies to DWI first, it applies to BACs, it applies to any of those types of crimes that involve alcohol. That's the only thing.
Okay, got
that
it.
we would, more clarification, I guess, Senator, is what we would ask for.
Okay, that's fair.
Mr. Chair.
Any questions for Daryl? Senator May.
Mr. Chair, I would like to divert this question to the bill handler. What is it on this exceeding 0.02% by weight of alcohol? What is the current, legal limit? What is that? Is this it? Because this seems, what I called,
Yes, I don't believe the intent is to change anything there, and I'm not seeing where you're
I'm on page,
on
I'm on the first page.
on the first
actually.
page. Oh, this is under definition of a failed start. So like what it means when someone has attempted to start their vehicle and the interlock device has prevented that start.
Okay, and so that has nothing to do with does that coincide with what we call legally intoxicated in the state of Missouri, or it does not?
I would have to double check that to be sure.
Okay. When you find it out, could you let me know?
Yeah, I'll be happy to get that information to you.
Thank you.
All right, any further questions for Daryl? Seeing none, thank you for your testimony. Any further witnesses for informational purposes?
Mr. Chair, members of the committee, I'll be very fast. Angela Nelson, AAA Missouri. We just want to point out a couple of things. AAA, like other organizations, generally oppose diversion programs, but it is the tying of this to an ignition interlock, which AAA is actually a proponent of, that really makes this a positive bill in our part, and we believe will save lives. There are two provisions in this bill that AAA views as critical in our analysis, and that is maintaining that the fact that records remain accessible to law enforcement and courts, and the piece that says if there's a subsequent offense, they're treated as a persistent offender. We also have two suggestions that we would like to make to the bill sponsor and the committee. Just like with MAD, we would like this to be first-time offenders who have not caused a crash where there's serious injury, death, or property damage. We think that's very important. If those other things are involved, it's a little more serious. The other thing that we would probably suggest as an additional requirement is that during this 1 year that they have the ignition interlock device, that they be required to maintain and provide proof of financial responsibility and SR 22. And with that, Mr. Chair, I'd be glad to take any questions, and I have letters for each of you in support. Thank you.
Any questions for the witness? Seeing none, thank you for your testimony. Any further witnesses for informational purposes? Seeing none, Senator Trent, any concluding remarks?
Thank you for the opportunity to present this bill. Appreciate the committee's consideration.
Thank you. That will conclude the hearing on Senate Bill 74. Next up, we're going to do a kind of a joint hearing on Senate Bill 146 from Senator Roberts and Senate Bill 53 from Senator Williams. Both of these bills have to do with restitution for individuals who are wrongfully convicted. And so if you're a witness testifying in support, in opposition, for informational purposes on your witness form, please just indicate whether you're testifying for one bill and not the other, whether you're testifying for both bills. That way it's clear when we're doing the committee minutes. And so we'll go ahead and start. We'll defer to Senator Roberts as a member of the committee, and then once you get done with your remarks, we'll kick it over to Senator Williams, and then we'll have witnesses come up on both bills.
Sounds good. Appreciate it. And I might step out. They're executing on another committee after I get my remarks, but I'll be back as soon as I leave that vote. Good afternoon. I'm State Senator Steve Roberts from Missouri's 5th District in the city of St. Louis. I'd like to thank the chair and members of this committee for affording me the opportunity to present Senate Bill 146 relating to compensation for wrongful convictions. Current Missouri law does not allow state restitution for wrongful convictions unless such convictions are turned over due to DNA evidence. There are obvious flaws to this law. Lamar Johnson was convicted without any such DNA tests. There was no forensics, gunshot residue tests, or ballistics. These types of tests were still in their infancy in 1995. Lamar Johnson was convicted due to an eyewitness account, and despite the shooting take place at night and the shooter wearing a ski mask. Since then, the eyewitness recanted coercive tactics that were used by the investigators, and the real shooters eventually came forward. Senate Bill 53, which this body passed in 2021, ultimately allowed prosecutors to reconsider past failed judgments like Mr. Johnson's. This ultimately led to his release after being robbed of 28 years of his life. At the age of 50, Mr. Johnson has to relearn what it means to be a productive member of society with no help from the state that wronged him. I cannot imagine anyone believing that they should not be compensated by the state that wrongfully convicted them and imprisoned them for nearly 3 decades. I also don't know how we put a price on those years lost, but this bill is at least a start. So the bill does 4 primary things. It repeals current provisions that only allow compensation for wrongful conviction by cases overturned to DNA evidence. It allows the state legal expense fund to provide payment of any claim or any amount required by any final judgment rendered by a court for the purposes of paying judgments arising from the claims for compensation for a wrongful conviction. It sets the scale for wrongful conviction damages, which is $179 per day of imprisonment, but no more than $65,000 a year, with other provisions concerning parole, lawyers' fees, as well as beneficiaries. It also allows for individuals under this act to receive tuition assistance. Thanks again for letting me present this bill, and I'd be glad to answer any questions if there are any.
Any questions for Senator Roberts? Seeing none, you got off easy.
Thank you.
Senator Williams, you're next.
Good afternoon, Senator Brian Williams, District 14, St. Louis County. I want to thank Chairman Luetkemeyer first for working on me with 53 and 60, which was the legislation you and I worked on in 2021, and it's the reason that Lamar Johnson and Kevin Strickland and countless others will be able to see freedom. I also want to thank the members of the committee for the opportunity to present Senate Bill 253 to you all today. The purpose of this bill is to make sure that our courts are fair and just, but also, let me be clear, if someone breaks the law, they should be held accountable, but no one should be punished for a crime that they did not commit. That is not justice. It's even worse to imagine that after spending an extended period in prison for a wrongful conviction, our state does not allow for compensation to be awarded to an individual without an exoneration based on DNA evidence. Kevin Strickland and, of course, Lamar Johnson, who's here with us today, are prime examples of why this bill is important. Most wrongfully convicted people spend years behind bars fighting to prove their innocence. Upon release, they face a number of immediate challenges financially, such as obtaining housing, transportation, health care, and other basic needs. Often, wrongfully convicted people have even less assistance transitioning home than those who were guilty of crimes and released with post-release services such as through parole. While wrongfully imprisoned exonerees missed out on opportunities to build work experience, further their careers, those are things that also make it very difficult for them to re-enter back into the workforce. While also incarcerated in the prime of their lives, they often missed out on critical economic benchmarks such as attending college, investing earnings, buying a home, creating retirement accounts, and contributing to Social Security. I'm really excited about the opportunity to bring this bill before the committee Clearly, it's something that's really personal to me to have gotten the opportunity to get to know folks who have been impacted by wrongful convictions. But of course, we should be thinking about how to put them on a path to be able to provide for themselves and their families. So, Mr. Chair, I appreciate the opportunity to present this bill. Again, I can't stress how pleased I am that you worked with us to get this bill across the line a couple years ago. And then I hope just listening to some of the testimony in support of it, you really understand why this is important to move forward with.
Thank you. Any questions for Senator Williams? Seeing none, first witness in support.
Good afternoon, everyone. My name is Ricky Kidd, and I'm here in support of Senate Bill 146 and Senate Bill 253. In 2019, I was exonerated after losing 23 years of my life, incarcerated for a double homicide that I did not and would not have committed. I was only 21 years of old, or 21 years of age when I was arrested in 1996, and I had my whole life ahead of me. I lost all my 20s, all my 30s, and half of my 40s before finally being exonerated August 15th, 2019. I feel that the future was torn from me when I was convicted in 1997 and sentenced to life without the possibility of parole, even though I had an alibi and even though there were evidence pointing to the real perpetrators of the crime. It took many decades for a judge to finally hear my evidence and to issue a strong order finding me actually innocent and releasing me back into society with my family and awaiting friends. But during that 23 years of being wrongfully convicted, I lost a lot. I lost a lot. At times feeling like I almost lost my mind. But fortunate enough for me, my cries were heard by the Midwest Sentences Project and other lawyers and community leaders that began to help champion my case of innocence and again brought me back into a free society where I should have never been taken. Despite those horrible circumstances, I tried to stay positive when I was on the inside. I took vocational training courses. I began facilitating programs for other individuals. Although I had life without the possibility of parole, I began to mentor those individuals who did have parolable sentence so that they had a real shot at reintegrating back into society. Sadly, those same individuals who I mentored had an opportunity when they came back out. They had resources that exonerees like myself, Lamar Johnson, Keith Corns, and many others do not have when we reintegrate back into society. Despite all that I've lost, I haven't got a penny from the state that wrongfully imprisoned me. However, the state of Missouri took away decades of my prime earning years. Again, all of my 20s, all of my 30s, and half of my 40s. I'm married now. I have a 2-year-old daughter, and every time I look at her, I'm constantly worried about financial security. And am I doing enough, and do I have enough to make sure that I can get her across the finish line at 18 or 19 until she makes her way out on her own? That's something that's important to me. I think that's something that's important to other exonerees like me, and I also believe that should be something that should be important to those who's taking a look at this bill. My past was full of pain and loss, but placing my faith in the future, I'm also placing my faith in you all to be able to pass a fair bill that would allow compensation where I would be eligible to receive $65,000 each year for my wrongful conviction, that I would go along, and that it would go along in helping to reestablish my life. If such can take place for the first time in decades, I would not have to struggle or stress about how I'm going to survive, not just for the day, but for the years to come. I hope that you will pass this legislation so that I can finally get justice as well as closure. Thank you.
Thank you for your testimony. I have a quick question for you. So whenever you said earlier that you had a judgment of actual innocence, so, and I also heard that your sentence was life without the possibility of parole. As you're probably aware, we have a little bit of a gap in Missouri law where you cannot file a habeas petition for a claim of actual innocence unless you're a death row inmate. So was your claim of actual innocence, was that raised in your direct appeal, or when was that issue decided by the court?
My claim of actual innocence was raised in 2019 in a habeas, a Rule 91 habeas petition, which included underlining constitutional errors as well as a full and flushed out claim of actual innocence, for which Judge Darren Atkins ruled in my favor on the constitutional issues as well as the actual innocence issues, for then which the state chose not to appeal. And so that decision stands as granting me release based on, again, constitutional error and actual innocence.
Okay, so you didn't have a freestanding actual innocence claim that you brought in habeas. You paired it with other constitutional violations.
I had a freestanding claim of actual innocence in my habeas.
I was not aware that Missouri allowed that. So we'll hear from some other witnesses later, maybe on that point. I know Senator Williams, I think, had intended to present on a Senate committee substitute today that actually clarified that issue of law. And I don't know if he wants to say a few words about that later. But thank you for your testimony.
yes.
Any further questions for the witness? Seeing none,
Thank you
for your testimony.
And thank you.
Let me just get a quick show of hands. Do we have any witnesses in opposition today to these two bills? Okay, any witnesses for information purposes? Okay, so it's all going to be in support. Okay, next witness in support.
Good afternoon, everyone. My name is Lamar Johnson, and just 6 days ago, I was exonerated and released after serving 28 years for a crime I did not commit. I wanted to thank this committee for its work in passing SB53 in 2021. That bill, which allows a prosecutor to file a motion to overturn a conviction, is what led to my release. Having been home just a few days, the difficulties of starting life anew after a wrongful conviction are fresh in my mind. I support SB146 and SB253 and urge this committee to pass it. It's hard to put into words what it's like to be free after losing 28 years. I'm ecstatic to be free and grateful to everyone involved in freeing me. But while I have regained my freedom, I have come out with nothing but the clothes purchased for me by my friends and my attorneys. I returned home free, but with no ID, no driver's license, no credit history, no work history, no rental history. I have no car, no furniture, no place to call home. I am overwhelmed by all I have to learn. Everything is so different. Cell phones, computers, cars with computers in them, ordering food on your phone. Everything is so different, and I need time just to learn the skills that everyone else uses each day. While there is a lot to learn, I am fortunate that I have some time to do so because of the financial support I have received through the kindness of strangers. When I was released, my attorneys started a GoFundMe account for me, and because my case received a lot of publicity, I have been lucky that thousands of people have donated to it, giving me a safety net as I get my feet underneath me and restart my life. But others are not so lucky. My friend Ricky Kidd, who lost nearly as much time as I did, but whose case was not well known, did not receive the same kindness. So while we were incarcerated together and have supported each other through the battles to prove our innocence in court, whether or not we have any financial support is left completely up to chance. Nothing can ever give me back what I have lost. I will never get back the time I should have had with my daughters, the career I could have had, or the holidays with my loved ones. But this bill would provide the security for me to get on my feet and to be there for my family in ways I could not. I'd urge you to pass SB 146 and 253.
Thank you, Mr. Johnson, for being here. And I'd hoped that you would come down to testify for the legislation, actually. And I think it speaks a lot to your character, the fact that you just had something very life-altering happen to you last week whenever you were released, and you feel the call for public service to come down here and to testify in support of legislation for people who are in the same situation as you, to make sure that they're supported and benefited. And so applaud you for doing that. Any questions for the witness? Seeing none. Thank you for your testimony.
Thank you for having me.
Further witnesses in support?
Hello, everyone. I want to thank the chair and everyone here for listening to us exonerees. My name is Keith Carnes. I was sentenced to life without the possibility of parole. I was released April 11th of 2022 after serving 18 years and 7 months. I'm here to support this bill, 146 and 253. I truly believe it's long overdue in the state of Missouri. Transitioning since I've been out has had its ups and downs, more downs than ups, but they're all ups considering what I've been through or what we've been through. So where I was incarcerated at, they didn't give the opportunity to pick up trades and that nature of things. So getting out, not having a job and having support myself has been difficult, you know, from housing to transportation. I have kids and grandkids that it's a long, it's a big wall to climb. But it's just a lack of housing, medical care, education, and financial stability are just mountains that I don't feel that after being found not guilty, I don't feel that we should have to get out and have to have those struggles. You know, people that have been found guilty for crimes and get out on parole, they give them so much. Us being not guilty and getting out, not having anything, I mean, that just doesn't make sense at all. We should at least get what the parolees get and so much more. So I'll just want to thank you guys for listening to us, and I hope that you feel our pain and our struggle, and it's long overdue in Missouri. And hopefully it gets done this time. Thanks.
Thank you, Mr. Carnes. Thank you for
Yes.
your testimony. Appreciate you being here. Any questions for the witness? Seeing none. Thank you for your testimony.
All right, thanks.
Further witnesses in support?
How y'all doing? My name is Joseph Amaran. I spent 27 years in prison, 17 years on death row. I've been out almost 20 years. I'll be out 20 years in July. I've seen the different changes with the death penalty, about the statutes and different changes in the laws and stuff. I mean, when I got out, there was nothing available for death row inmates, exonerees. I guess we was new back then, but since then it's a whole class of us, and we're all suffering. You can only imagine what it would cost for someone like me to get mental care. 27 years in prison on death row does a lot to a man. Every day is a struggle. I've been out 20 years, I'm struggling every day. Every day I wake up, I find something new that's wrong with me. And it's gonna be like that from now on, and we don't have the help that we need. It's a shame when I see people who've been in jail for 20 years like me for something they did commit. And yet they come out here, they get food stamps and Social Security and Section 8 and Medicaid, And here I am, I'm being punished because I wasn't guilty. You know, I mean, it's just not fair. You know, I feel like I've been punished twice for something that I actually didn't ever do the first time. You know, and one of the worst things about this situation is this here. I've been out 20 years. I've never been given an apology. No one ever said, we're sorry, you know. And I'm not the only one who feels this way. You know, I just feel that, you know, we as a community, we should try to help each other. If we don't get the help that we need, some of us might fall back in them same old holes and might get out here and do something wrong, you know, because we don't have the help that we need here. You know, we need help. You know I need help. So that's why we're here. You know, we asking for help, you know. And I appreciate y'all listening to us. Thank you.
Thank you, sir, for your testimony. Any questions for the witness? Seeing none, thank you for your testimony. And if you can remember to leave a witness form if you haven't already filled one out. Covered. You got good people helping you. Further witnesses in support.
Hello, my name is Joshua Keyser. I'm put in a very unique situation today. Pardon me if I'm a bit emotional. It's rare for me, very rare for me to be in a room with men who make, I'm sorry. It's rare for me to be in a room with men who make my situation seem small. I spent 16 years in prison for a murder I did not commit. For about the first year that I was in the county jail, I faced the possibility of the death sentence. And then I was eventually convicted of second-degree murder. I was sentenced on what would have been the victim's 21st birthday to 2 30-year sentences to run consecutive. The next day I was sent to the Department of Corrections, and the DOC changed my sentence without the permission of the court to a 60-year sentence and put me under life sentence sanctions that I was never sentenced under. I was told years later that they did that because it made their paperwork more simple. In 2008, I was finally granted a hearing in Judge Richard Callahan's court here in Jeff City, and I was granted actual innocence in 2009. And I had the honor today of meeting Joe Hamron. Judge Callahan gave me Joe's decision. Changed my life. You know, I had no plans, honestly, of coming in here and telling my life story. Sometimes I want to take a back seat, and I want other people to shine. I want other people to have the opportunity to be highlighted. If I may, I mean no disrespect, I wrote something. I wasn't able to get it printed, so, and it more addresses the issues. I put a lot of thought into this, so please, I'm just trying here. In preparation for addressing the Senate today in matters of exoneree compensation and awarding damages for wrongful convictions, I discovered the word tort last night. Prior to last night, I'm forced to admit I had been unfamiliar with the word. The term derives from the Latin word tortum, meaning something twisted, wrung, and crooked. Tort is a wrongful act or an infringement of a right other than under contract leading to civil legal liability. That should then qualify and offer exonerated wrongfully convicted men and women access to the Missouri Tort Victims Fund, currently having $480 million in it due to the recent Johnson & Johnson lawsuit and $2.12 billion punitive damages award. The Tort Fund exists to provide for victims of wrongful acts committed by the state. The state of Missouri is culpable in the wrongful act of wrongful convictions and wrongful affirming of the state's wrongful convictions and failed appeals prior to the state of Missouri's exoneration, and enforcing the exoneree victim to endure inhumane living conditions and torture, in most cases decades prior to exoneration. No amount of money would ever be enough to right the wrongs committed against us. but it would be argued, at minimum, exonerees should be afforded $100,000 every year for the rest of their life, or up to 30 years. We're not a victim demographic with millions of residents in Missouri. We haven't even accessed 100 current exonerees. Though we estimate the numbers to far exceed that, what's on record, Missouri has had approximately a few more than 50 total exonerees on record. I'm sure less than 50 are still alive, but if the 50 were and were provided for at least 30 years annually, given a tax-free $100,000 deposit, it would amount to 50 times 100,000 equals $5 million a year. 5 million times 30 equals $150 million for 30 years, leaving an enormous $330 million from the $480 million currently available. Basically, the argument being the current statute being presented today may have a higher likelihood of being passed, but it isn't sufficient given the current tort fund. There's more to go around in Missouri than in other states. Whatever the statute in Kansas and Indiana, that suffice with them. Neither of them have had the tort fund Missouri does. $400 million is a lot of money for tort victims. There's plenty to go around. Exonerees deserve their fair share, and I get a little bit off statement here. I'm in tears because I've heard why they deserve it today. Being as Charlie Weiss of Bryan Cave Leighton Paisner is my attorney and has had more than 40 years experience in business and in complex litigation, representing numerous Fortune 500 companies and other clients in significant litigation matters involving class action, I ran the issue of accessing the current tort in class action by him. He sees my point, that being there's more than enough to go around for exonerees given the current $480 million fund, though acknowledges the complications and complexities before us. Example, Lamar has immediate needs. Keith has immediate needs. Joe has immediate needs. Ricky has immediate needs. We need a statute to provide for them and others immediately released. Still, I wonder if we shouldn't fight for more than this current statute asks for. The argument in favor of this statute is politicians, I won't attribute it to this, but I heard this. Politicians won't look at just what's in the tort fund. If you look around the country, what's in this bill is one of the higher amounts that other states have passed. The largest is $75,000. So even if the math adds up with money in the victim's tort fund, the politicians aren't going to just say yes to that. And that tort fund has to cover other people and other kinds of cases, even things like slips and falls. Get back to me when slips and falls for 16 years of strip searches, being walked with dog leashes, and being caged like animals and unconstitutionally sold like slaves. Looking around the country, I'm forced to see isn't enough. Adversity makes strange bedfellows. Difficult circumstances will bring together very different people. Missouri needs to provide for the wrongfully convicted. My position has been Missouri should, at the very least, provide for their victims of gross injustice this list. A year's rent and utilities up to $1,200 to $1,500 a month, or provide $1,000 a week for the first year for living expenses. Full medical insurance for 2 years, including vision and dental. A full scholarship to the in-state college or university of the person's choice. 2 years of therapy to the therapist of the person's choice. $10,000 for a car and a year of car insurance for transportation. 1 year of VOTEC training of the person's choice in addition to full scholarship. Restoring an exoneree's ability to choose his or her own course is of paramount importance. And these should just be the auto-triggered provisions upon exoneration, whatever the form of exoneration. Brady violation, DNA, or actual innocence. Then there should be further non-taxable provision given every year for the remainder of the exonerated man or woman's life. If not $100,000 annually for no more than 30 years, totaling $3 million, no less than $50,000 a year for the remainder of the exoneree's life, likely totaling less than $3 million. An argument could be made for removing state tax requirements altogether from exonerees if they choose to continue living in Missouri, and that these auto-triggered and further provisions should both be retroactive, unrestricted, and available to all Missouri exonerees, regardless of suits filed directly against counties directly responsible or suits settled or won. Perhaps a measure this strong would better deter gross injustice within Missouri's justice system and encourage accountability within its sheriff's departments, prosecutors' offices, judges' chambers, jury deliberation rooms, and courtrooms. I'm almost finished. Thank you for your patience. It troubles me to consider anything shy of this will merely seek to pacify our victims' rights. We are Missouri's victims. Victims of inhumane torture, injustice, mental and emotional regression, character assassination, and loss of family and years of our lives. I will not try to convince you to love us. I shouldn't have to. I would hope that by natural and bipartisan legislative course, you would choose to love and respect us and vote to provide for us because you believe it's the right thing to do. I have 14 years out now. My 14-year anniversary of exoneration was the 17th of this month. My 14 years of release was the 18th of this month. I have been blessed to have won a civil suit. It has still been very difficult for me. I have to be very careful with my money. I have to make very smart decisions with my money, and I'm thankful that I have been able to do that, and I have exercised the wisdom to surround myself with people that help me do that. But this is about more than money. Like Joe pointed out, therapy is extremely expensive. Right? I mean, Keith, we see the struggles he's going through. Lamar, right now, God love him, he's in the euphoric moment of being free. But those of us who've been out for a while know what's coming for him. And we have an opportunity today to either do the very least, and I say this honestly, the very least, and pass this gentleman's bill. Or maybe even take it a step further, because you, sir, from what I hear, you guys work together to take some steps further that have benefited men, and we've got to hear those men today. How beautiful would it be to work together to enhance what's being presented here, to go even the extra step. And then maybe years from now, we get to see the benefits of that with some of the same men in this room. I thank you for your time. I thank you for your consideration. I live in Columbia, so I'm easily accessible. If anybody here wants to contact me and would like to ever get my feedback on work like this or any work, I'm willing and I'm available. Thank you.
Thank you for your testimony. Any questions for the witness?
I just assumed.
Seeing none, thank you for your testimony. Remaining witnesses, we're going to limit everybody to 2 minutes.
Thank you, Mr. Chair. Hello. Hi. My name is Base Goggin. I'm a state policy advocate with the National Innocence Project, and I'm here to testify in favor of both bills and support them. And I am going to take us a little bit back into the realm of the mathematical and intellectual. I don't think the emotional case for these bills needs to be made any better than it's already been made today, and I'm very grateful for all the exonerees for their testimonies. What I really think is important to talk about is the economic potential that's lost. You know, the famous quote from Einstein is that compound interest is the eighth wonder of the world, and I was just doing some back of the napkin math, and $250 28 years ago, if you just put $10 in every month, is more than $40,000 in today's money. So just with a minuscule amount of money, we could have had significant better resources for these individuals, and this state has unfortunately, and through some wrongful actions and through some mistakes that we're working to commit, and by the way, thank you for your work on Senate Bill 53, but we have the opportunity to rectify the economic loss, and that temporal factor in the economic loss is significant. It's also very, very likely that passing this compensation statute would save the state money. In terms of publicly available settlements claimed currently, there's more than $50 million in payouts from the state. That's just what's been publicly available. Now, what I will tell you is that this next fact that I have for you is definitely anecdotal. It's important to note that it's anecdotal. But what we see very often is that exonerees will very often choose whether or not to file a case based on the fact if there's a compensation statute that is sufficient or not. And so having an offset provision like there is in these bills is crucial, but it's also important to note that the average case for a civil settlement claim is 7 years. So it'll take exonerees 7 years if they want to go through the trauma of dealing with the court case, proving their innocence, proving the wrongful nature of the conviction, and moving on from that. So it's really, really crucial that we allow them another avenue, because more time in court is not good for the state, it's not good for the exonerees, and it's not good for the victims. So with that, I'll stop and stand for questions.
Thank you for your testimony. Any questions for the witness? Senator Coleman.
Could you come by my office, please? I just want to talk to you offline.
Absolutely.
Thanks
you,
so
Senator.
much.
My pleasure.
In the interest of time, not like getting called into the principal's office.
I'm in trouble.
Further questions for the witness? Seeing none, thank you for your testimony.
Thank
Next
you.
witness in support.
Thank you.
Good afternoon, committee. My name is Tricia Rojo Bushnell, and I'm the executive director of the Midwest Innocence Project. We represented Kevin Strickland, Lamar Johnson, and Ricky Kidd, who you've also heard from today. I'll be very brief because I'll just let you know we're submitting our testimony in support as a written testimony. I don't need to repeat what you've already heard today, but I did want to also just address some of the provisions, I think, Senator Luetkemeyer, that you were talking about before about actual innocence claims. We will be working with the sponsors of this bill to address some of the language that has been added in committee about the actual innocence claims. But to ask the question of, has there been someone who's gotten actual innocence, right, with, even though they didn't have a death sentence? So the answer is sort of yes, but also no. So Mr. Amrine, who you heard from today, Joe Amrine, in 2003 was exonerated by the Missouri Supreme Court. And in Mr. Amrine's case, they made what we are now know what's called the Amrine Standard, which says if you are innocent, that is a reason for you to get out of prison. Because in the federal system and in many states, innocence actually isn't a reason to get out of prison. You have to have a constitutional claim. So Missouri Supreme Court in 2003 said no, innocence is a reason, and Mr. Amrine was exonerated. After that, you'll hear from other folks, like you heard from Josh Keyser and you heard from Ricky Kidd, where they were also exonerated, but they had other constitutional claims. So in Ricky Kidd's case, for example, there was a Brady claim, which means there was a suppression of evidence by the state, and so he won on that as well as actual innocence. But so in 2003...
Now, I do have a quick question.
Yes.
Because we've got a technical expert, so I want to ask a few technical
absolutely.
questions. So, one of the things in this bill I think that we're going to be working on is, and everything that I've heard today, all the witnesses, fit this mold. There can be a technical constitutional violation, and a conviction can be reversed, and it can potentially be retried. But that's not the same thing as an exoneration, right? You would agree with that?
So an exoneration can be if you win on a constitutional claim and then the charges are either dismissed or you win again at retrial. So that is a definition that's also used by the National Registry of Exonerations.
Okay. So if the charges are dismissed, I mean, there can be a whole host of reasons why the prosecutor would do that, right, other than actual innocence. And what I'm really getting at is what we're attempting to do in the statute is to compensate people for claims of actual innocence. If somebody is released due to a technicality and not recharged, but there's never any proof of innocence, that's different.
That's correct, because the way the statute is written, and we can also look to our neighbors in Kansas, which has a similar statute on the books, when it's filed, when the compensation claim is filed as a civil case, they do have to find that that was on the basis of innocence, and then they issue what's called a certificate of innocence, and then that is what then leads to the compensation. So, for example, if you look to our colleagues in Kansas, where we've had other clients who were exonerated, the folks who were exonerated did receive compensation, but other individuals who may have said they were wrongfully imprisoned but were claiming innocence under that same definition did not, because it had to go and meet that same standard in the civil case that you're talking about.
Okay, great. Go ahead and continue.
Yes. So when Mr. Amrine was released in 2003, part of why they said he was innocent was there was no evidence left to convict him. Fast forward to 2016, my office, myself, I represented a man named Mr. Rodney Lincoln, who also, just like Joe Amrine, we had found all of the evidence that was used to convict him no longer was sustainable, right? The eyewitness had recanted her identification, and DNA had proven that the evidence they said was his was not left behind by him. But when we went into court, the Western District Court of Appeals said, well, no, Joe Amrine's case was a death penalty case, and so now innocence is no longer a claim, right, unless you were sentenced to death. The Missouri Supreme Court has not taken that up on review. They did not take up Mr. Lincoln's case. They've not taken up other cases on that same issue. We at the time, when we represented Mr. Kidd, continued to argue, well, we don't think that's dispositive, right? And when Ricky Kidd was exonerated, a lower circuit court said, yes, we have a Brady claim, a constitutional claim, and we're going to find you actually innocent, but then it wasn't appealed because obviously there was also another constitutional claim. And then after that, when you continue to look at the subsequent rulings, including now on the eastern side of the strait out of St. Louis with Mr. Dunn's case, where the court has said we cannot reach it because the Missouri Supreme Court has not clarified for us or told us. And so the courts have now decided since then that it is very clear that innocence is not a claim if you're not sentenced to death.
Okay, so just to clarify, just so I understand all the nuance, so individual on death row, freestanding actual innocence claim recognized under habeas per Missouri Supreme Court.
Correct.
Claims of actual innocence that are combined with a constitutional claim that would be an independent justification for releasing the person recognized in habeas, and you can attach an innocence claim to that. Freestanding actual innocence claim in habeas for anything less than any penalty less than death, not recognized by the Missouri courts.
Correct. So anything less than death, they don't recognize the freestanding claim. What you're talking about, the other ones we call a gateway claim of innocence.
Claim,
Yeah.
yep.
Mhm.
Okay.
Correct.
Any questions for this witness? Seeing none, thank you. Or Senator Coleman.
I'm just going to ask the same thing. If you could come by my office, that'd be great.
Of course.
Thanks so much.
Principal's office inquiry. So we had two of those. Any further questions for witness? Seeing none, thank you for your testimony. Further witnesses in support?
Darrell Moore, Executive Director for the Missouri Association of Prosecuting Attorneys and Missouri Office of Prosecution Services. We're here again in support of this bill. It's similar to bills that we testified for last year that Senator Washington introduced under Senate Bill 1094, which would allow for reimbursement of actual innocence cases where, in non-DNA cases, under the current statute that's mentioned, it only recognizes actual innocence in DNA cases where you're exonerated. We also agree that's not fair. We were pleased to work with Senator Williams and the chair on Senate Bill 53 because any career prosecutor desires that no innocent person be convicted, and if they have been wrongfully convicted, that there's an avenue. So we proudly supported that bill, and you cannot help but be moved by the testimony of these men that have been wrongfully convicted. So that would be my testimony in short, is that as we testified for Senate Bill 1094 last year that Senator Washington proposed, we would be in support of these two bills also.
Great, thank you, Darrell. And let me echo something you said, and I'm sure Senator Williams shares this as well. I do appreciate the prosecutors working with us on Senate Bill 53 and 60 a couple of years ago, and it is true that when I was sitting in my office with the Prosecuting Attorneys Association, the association was the first to say the worst miscarriage of justice from the criminal justice system is when somebody is wrongfully convicted and sentenced to prison, and that the prosecutors worked very diligently with myself and Senator Williams to right that wrong. So I thank you guys for that, and thank you for being here again today. Any questions for Darrell? Seeing none, thank you. Further witnesses in support?
Hello, how are you guys today? Thank you for allowing me to be here and speak to you all. I really appreciate it. My name is Latara Smith-Carnes, and I'm here to speak up for my brothers as well as my husband, Keith. Being a family member, I just kind of want to give you guys just a look at it from being a family member and having to deal with receiving an exoneree home, how difficult the transition is, the struggles that they have. They've told you some of them, but there's a whole lot more. And one thing I can really appreciate about this particular bill is the fact that it's going to cover therapy and medical, because that is most definitely needed. Imagine being locked up 18 years, 22 years, 28 years, locked up, away from your family, your friends, told when to do, what to do, how to do it, when you speak to your family, if you hug your family. You can't oppose anything. If you do, you're sent to the hole for multiple. Some people get locked up in a hole and never get out for months, okay? Imagine being in that and then coming home. You have such a restricted environment. You're lost. You don't even know what to do with your days. Not only do you not know what to do with your days, but it's hard for you also to come back into the family unit. Counseling and therapy is needed. I mean, I'm like trying to fight back the tears because I know the struggles that my husband has. I know the struggles that my brothers have. They're sitting here before you like strong men, but they are hurt and wounded men behind their cores. Trust me. It is an adjustment for them. I live it out on a daily basis. And did I think I was going to have this knight in shining armor come home and marry me? Yes, I did. But I can tell you, it is a struggle. It is a struggle for the family. It is a struggle for the exoneree. It is. They're so unsure of their future. You know, I also work in reentry, working with men and women coming out of prison, and I can tell you, even when we're working with someone coming out of the Missouri Department of Corrections that have medical issues, DOC will give them medications for 3 months, for 90 days. I bet you none of my brothers here got anything for 90 days. Because I know that I've tried to help people. There was a guy, Elvis Williams, we tried to help him to get his meds. This man had had a heart attack. We tried to get his meds, but because he was let out, and he wasn't on probation and parole, DOC refused to give him 90 days of meds. We had to do like a GoFundMe and get money together to pay for his meds. Therapy is very expensive, and therapy is something they need. The moment they walk out of that prison and hit the door to their families, they need therapy. Because if they're not mentally stable and mentally secure, how can they move on to try to get a trade? How can they move on to try to pursue any type of self-sufficiency or stability? They can't do it. And then even some of these prisons like Crossroads, when those guys are in there doing life without parole, if we compare that facility to Jeff City, they had a lot of programs for the men. I think Mr. Johnson was released from Jeff City. But Crossroads, you're in there with life with no parole. They don't even try to help you to do anything, to get a trade or an education or anything. So you come out, you're lost. You're lost. And so I really want to thank you for what you've done. And I want to thank you all for hearing it. And it is my prayer that this gets passed, because it's really needed on more levels than you all can probably imagine. It is really needed.
Thank you for your testimony.
You're welcome. You all have a blessed day.
Great. Any questions for the witness? Seeing none. Further witnesses in support, and we are going to limit testimony to a minute now because we're running up against caucus.
Thank you. Good afternoon. My name's Elise Max. I'll be very quick. I think we've had some great testimony today. I am a co-director at Missourians for Alternatives to the Death Penalty. There are 4 individuals who've been exonerated from death row in Missouri. You heard from Joe Amrine earlier. I just want to go on record in support of this bill, and thank you for bringing it forward.
Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none. Next witness in support.
Thank you, committee. I'll be brief. My name is Kurt Wickmer, and I represent the Missouri Catholic Conference in support of this bill. The state bears responsibility to make sure that no innocent man goes to prison. Likewise, the state bears responsibility to make sure that those falsely imprisoned get the restitution they deserve. Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none. Further witnesses in support.
Chairman, committee members, Casey Nail representing Empower Missouri. Just also want to go on record in support and thank the sponsors.
Thank you for your testimony. Any questions for the witness? Seeing none. Further witnesses in support. Any further witnesses in support? Seeing none. Senator Williams. Senator May. You have a question?
So, no, I don't have a question. I have a statement. So we have heard, the testimony of you all. And I just want to say from this side, listening to the family perspective and from your perspective, what has happened to you is an egregious miscarriage of justice, and you all deserve restitution for that miscarriage of justice. Not only what has happened to you, what has happened to your family, because while you were in there, I'm sure your family had to sustain you in paying money so you can get things that you needed to have and all of that, sending care packages and things like that in all of those years. So I want to encourage you to keep the fight and to keep the pressure. And one person I know is an excellent restorer of justice, and that's God. And so if you don't know him, get to know him and keep the fight going.
Thank you, Senator May. Senator Williams, do you have any concluding remarks?
One, I want to thank you, Mr. Chair, as well as to the members of the committee. I do want to just address real quick some compensation numbers. So the average amount paid to exonerees in states, compensation statutes is $70,000 per year of wrongful incarceration. So that's how we got to that number. There's 19 states that offer $50,000 or more per year for wrongful incarceration. And then by contrast, Missouri offers just $18,250, tied with Iowa for the lowest in the country among states that articulate an annual amount. So that's just giving us an idea of where we are in terms of compensation. I do want to recognize a couple people because, again, it wouldn't be possible without them, but if we can just recognize the hard work of the Innocence Project, their executive director, Tricia Bushnell, Bay Scoggin, Lindsay Reynolds, that you guys may know her as Senator Rizzo's wife, and then countless other attorneys that played such a significant role in freeing these gentlemen. And the only thing I really took from this hearing, outside of the importance of getting this bill done, is the only thing that separates me from them is the fact that that what happened to them could have easily happened to me and countless others. We all come from circumstances and environments that don't always afford us the luxury to avoid being accused of things or just getting in trouble in general. So I'm very inspired by these gentlemen. And again, the only thing that separates us from each other is the fact that they were wrongfully accused of a crime and I was not. So thank you so much, Mr. Chair and the committee. And again, I hope we get this bill across the finish line.
Thank you, Senator Williams. No further business coming before the committee. I would now make a motion that we adjourn. Do I have a second? It's been moved and seconded. We're adjourned.